When it's Monday and it's 7 p.m., you know that will come your way eventually. Tonight, my name is Naa Afarley Quarcoo, and of course, we are coming your way live from our studios here on the John Evans at Mills High Street. It's Regulators. Today, we're discussing a lot of issues. One has to do with strikes. When we mention strikes, I hope that those watching us would definitely think that we are going to discuss something from UG. Yes, most teachers, most lecturers are on strike. As and when or what has actually happened that brought about the strike is what we are going to find out. Are they legal? Are they illegal? Is there something we can call a legal strike or an illegal strike? What brings about these issues? Is it that someone is not meeting his or her target, or someone is demanding for something that we are not able to give out to that person or to those group of persons? Today, that's what you're going to find out. So stay with us. When we come back from this break, we'll continue.
Welcome aboard the safest airline in Africa. With industry-leading safety measures to protect your well-being. The first in Africa to earn a diamond standard of safety. Offering a more contactless, safe, and seamless experience. Delivered with a smile by Africa's first fully vaccinated crew. Creating special memories that bring the joy back to flying, so you can continue making memories with your loved ones. Book your flight with Rwandair today. Rwandair, the safest airline in Africa.
Rwandair, fly the dream of Africa.
Blue City is a manufacturer and supplier of high-quality fashion accessories. We design and make quality bow ties, flying ties, lapel pins, ladies' brooches, fabric necklaces, African wares, and so much more for your weddings, schools, institutions, bands, choir, singing groups, individuals, and so many more. We use both African prints and foreign fabrics to make your beautiful accessories for you. Oh yeah! Contact us via call or WhatsApp or SMS on 0240 926 564. Locate us at Odoko Official Town opposite Emils Preparatory School. Check us out on social media, Facebook and Instagram at Blue City Fashion. Blue City, creativity and style.
Major thanks for staying with us. We are back again, and this is the Regulators. I've been joined by Miss Eunice Lawe. She's the head of public affairs for the National Labour Commission, and to my immediate right is EDK Totime. He's also a member or part of the public affairs department. He's an officer there. Hello, welcome. Oh, good evening. I'll respond for them. Auntie Eunice. Well, let me just make it, on a lively note. Eunice, now recently we've been hearing of strikes, but when would we wake up in a whole year and not hear something of that sort? What are they? People decide to go on strike.
Well, workers decide to go on strike when there's an issue, let's say maybe condition of service, or they are not satisfied with their the pay that the employer paid them. And so on. So they can decide to go on strike for better service.
But wasn't their condition of service spelled out in their letters or whatever was given to them before they started work with that particular firm?
Sometimes the workers or the employers, when they are employing the people, they don't give them they don't give them the guidelines or the what they are supposed to know or what they are supposed to. I don't know how to describe it. They don't tell them what they are supposed to get or what they are supposed to know. So sometimes when they work for some time, they say, "Oh, fine, because of so and so, we want to go on strike for better service."
This word that is better service, we need
Better
to find
condition.
what the better working condition is all about. Tazime, what would you say strikes are, and why do people go on strike or workers decide to go on strike?
Thank you very much. Strike generally can be determined whether it is legal
Or illegal. Yeah.
based on how the process is contracted. In some establishments, there are laid down procedures to embark on strike.
Okay.
There are steps that one will have to follow by going through certain channels of grievance procedures and resolutions. If that is not followed, you cannot rise up and say you are going on strike. So when you take the Labor Act of Ghana, the Act 651 of 2003, it clearly spells out the procedures that any institution or any union or a group of people can follow before they embark on such industrial action. And so if you do not follow those steps, your strike definitely is declared as illegal.
Okay.
And it is the National Labour Commission or a court of competent jurisdiction that can declare such strikes as illegal.
So what we are experiencing now is illegal, or it is legal?
Which one?
The lecture strike. Is it legal or illegal? Or it stands in between?
Currently, the issue is pending in court.
Okay.
So we may not want to delve into it. Okay. But if we are giving the explanations that the Labour Commission has already given on that strike at the commission, prior to the case being forwarded to the court, we would say that the UTAC strike is illegal.
We'll still hold on to that because we know that the courts will definitely bring its own verdict. But Eunice, what are the processes that workers would have to go through before saying that from this day until our demands are met, we are going on strike, or we are going to sit down in our offices and decide not to touch anything, decide not to do any work, except, of course, maybe it has to do with someone saving a life or any other thing?
The law says, the labor law says, spelled out clearly that if you want to embark on strike, you have to inform the Labour Commission 7 days.
How do you do that?
7 days before you go on strikes.
Okay.
And any party who refuse to do that, it means you are trying to disobey the law of the commission or the law of Ghana. That's the Labour Act.
So how do you give out the notice to the Labour Commission?
You have to write to the commission. Okay. No, you have to write a letter to the commission informing the commission that maybe so and so date we want to embark on strike. So after the 7 days expiration before you can go on strike. That is what the law says.
Okay.
651.
So in between the 7 days, what is the Labour Commission expected to do? If within the 7 days ultimatum, what should we expect from you?
Okay, fine. Thank you for the question. When it happens, we have to write. When you write to the commission, then we invite the parties to the negotiating table.
Who are the parties involved?
The worker and then the employee and then the employer.
Okay. And
to the negotiating table to ensure that the matter is being resolved between the parties.
Okay. How long does this take to talk to the two parties?
Ideally, when the case is brought to the commission, it should act expeditiously. And so we invite the parties and then the case is heard. It is definitely based on something that they have taken that industrial action.
Okay.
Either on their remuneration or salary or poor working condition at the workplace that they want it improved. And so when it comes to the commission, we direct most often the employer to sit down with the employee and negotiate, so that through the negotiation process, both parties will have the opportunity to hear from each other and come up with a resolution. If the matter is not able to get resolved at their negotiation table, then the law also states that the matter should be referred back to the Labour Commission, so that the Commission will use its arbitration powers to now give a ruling or a directive as to how such issues should be handled. So we can direct on what should be done when it is eventually brought back to us. But if they are able to resolve it at their level, at the enterprise level, then what we expect from them is that they now come back to the Labour Commission and report to us that we have gone to the negotiation and this and that were the outcome which we have both agreed upon, and they sign to it, and it becomes a legal document which is binding on both parties.
But what is expected of these two parties to bring on board? Is it what they are asking for or what they are demanding for? And then the one at the tail end that is receiving this backlash, what is also expected from that party?
Can you come out again?
I'm saying that the employer and then the employee, what are expected? What do you expect from them when they sit on the table or when they sit at the table? Okay, you can go ahead.
So when you are coming before you appear, when you are coming to the commission, the commission will ask you that when you have any document, that is maybe appointment letter or termination letter or any condition of service letter, you have to bring it along.
Okay.
And based on the document that you present to the commission will determine the matter based on what you present. I mean, both parties, the worker and then the employer.
Okay.
Yes.
So after these two parties have gone back, I mean, they've come to see the Labour Commission, they've gone back to sit on the issue, to resolve it, and then bring the outcome to the commission. After the outcome is brought, do you document it so that it becomes...
We have a database for that.
Okay.
Yes, so should in case anything happen, we can just prove it that so and so party were here or came before the commission, or so and so case, or they brought it before the commission. Yeah.
Because have you had instances where, I mean, they bring back a document that says that the two of us have agreed on this, but after a period of time, they come back with the same issue?
Yes, it happens.
Okay.
It happens. You see, I want to give an account adage. I don't know whether it's permissible.
Oh, it's permissible.
There is a saying that anwa yede tonye no ani editia. There are certain instances that they will go on the negotiation table. They will come out laughing and happy, indicating that they have been able to come to a compromise. They have all resolved the matter amicably and go back to continue with work with the expectation that whatever conditions that they went to is going to be adhered to by both parties. And after a period of time, there will be agitations again, and one party, most often the one who is at the losing end, will run back to the commission and report to us that this is the situation. After the negotiation and then coming up with terms and references, the other party has not been able to go by the conditions, and so we are coming to report to you. And it does happen, even from state institutions, as well as the private institutions. It does happen.
So the process...
So as an independent arbiter, the Labour Commission now invites the parties again to the commission to find out what the issue has been. There are certain times that due to one condition or the other, the negotiations that have already been done cannot materialize at that given time or at the specific period that both parties have set themselves to. And so when it happens like that and they come to us, we look at the conditions again, and then we find ways to ensure that both parties are able to meet the needs of the other in a way or the other. So that if it's not 100% of what you are entitled to, at least something that can cushion the fellow or the party at a particular time until such time that they are able to now get all their demands. That is also looked into. These are all possible conditions that are there for them.
What should an employee look out for when you have your conditions of service? Be it a booklet, be it a paper that has been given to you by the employer. What should we look out for?
Worker,
a basic one.
As a worker, when you have condition of service, you have to make sure that the right is being done by the employer.
Okay.
I.e., you are supposed to go on leave for maybe 15 days annual leave, and when the time is due, the employer is saying I don't go. You can use that document to file a complaint at the commission.
Wow.
Of course.
So every year everybody's entitled to leave. So if you don't, or whoever has employed you doesn't want you to go.
Leave.
Okay.
Yes.
So you can report.
You can report the matter to the commission, and then the commission will invite the parties and then resolve the issue.
Okay. So that's a basic one.
Yes.
Yes. At least 15 working days.
Okay. That's the minimum
for the employer. The minimum.
So the 15 working days, does it include a weekend?
No, it's not. Weekend is not part of it. Monday to Friday.
Monday to Friday.
Working days.
Working days. Interesting. Now, when it comes to issues of salaries, which parties or which state institutions sits on this round table together with the parties involved? Otime?
Okay. The laws of the land mandates the Fair Wages and Salaries Commission.
Okay.
To spearhead such negotiations on behalf of government.
Okay.
Yeah, so in many of the state-owned institutions or agencies, it is the Fair Wages and Salaries Commission that the law mandates to do a negotiation for the employer with the employee.
Okay.
Yes. And of course, the Ministry of Employment and Labor Relations, which is the mother ministry of the Fair Wages and Salaries Commission, also have key role to play in such instances.
So when it gets to this stage, it means that the Labor Commission doesn't have much to say.
When it comes to determination of salaries and emoluments of workers, the Labor Commission doesn't have a hand in it.
Okay.
It doesn't have a hand in it. It is after there has been determinations, and what the party or the employee is supposed to get, he's not getting, and then he wants to come to the commission to present its grievance to us. That is when we come in. You know, the National Labour Commission, as established by an Act of Parliament, Act 651, it gives the commission the authority to act as an independent arbiter. So it doesn't matter whether it's a state-owned institution or a private organization. The Labour Commission has the power to sit and then ensure that such matters are resolved amicably by its institution.
Ines, is there any law that makes strike really legal?
When you look into the law,
the
Labour Act 2003 C51, section, I think 159, spelled out legal and illegal strikes.
Okay.
Legal strike is when you inform the commission the day, the time you want to embark on the strikes.
Okay.
And it doesn't.
And then you also say yes to it.
Yes. And it also terms as illegal when you refuse to inform the commission that so and so dates, we workers of so and so want to embark on strikes. That is where it comes illegal.
But how would you say yes to a strike? Labour Commission, why would you say yes to a strike?
Well, Labour Commission will say yes to the strike, inviting the parties to come for the negotiation.
But you're still giving the nod for them to go on strike?
No, so when you inform the Labour Commission that you want to go on strike, we invite the parties, we quickly do a letter, and then invite the parties to appear before the commission, then trying to resolve the issue before it gets out of hands.
So in trying to resolve the issue, are you saying that the people should still continue with their work?
That is
until
why
the issue has been
when you
resolved?
inform the commission that you want to embark on strike, we will invite the parties to appear to avoid the strike. So we invite the parties to appear before the commission to resolve the matter.
You see, that is
Okay.
I just want to add up to
Okay.
what my sister. That's the beauty of the provision that the law makes.
Okay.
When you give the commission a 1 week notification or a 7 days notification that you intend to embark on strike, you see, the beauty of it is that the Labor Commission will quickly put together a letter and invite both parties for a hearing. So we wouldn't sit for the 7 days notice that you have given us to elapse before we invite you. Immediately you give us the notice that you intend to embark on a strike action due to this and that reason. Before that 7 day elapses, the Labor Commission will certainly write to you and invite the parties for a hearing.
Okay.
So in this case, when you come for the hearing, then we determine the matter. If it is supposed to go to the negotiation table, we tell you, the parties, to go and sit down, and then you negotiate. And so the Labor Commission has the authority to determine a strike which is legal or illegal. If the strike is illegal, we spell it out clearly to you, and then we ask you to call it off immediately so that you proceed to work whilst you negotiate on the conditions
Of service.
of which you intended to embark on the strike, or you took that action.
The law also say that, let me add to what my brother said.
Okay.
Under section 161 says cooling off period, meaning when negotiation is underway, you don't have the right to go on to continue the strikes. You have to call it off because negotiation is still underway.
So there's nothing like cooling off. You need
No,
to come
so
back to work.
that is why I said when negotiation is still in progress, you don't have to go on strike. That is the cooling off period. You have to adhere to what the commission say, or what the commission directive, or whatever the commission has given. You have to obey it because negotiation is still underway.
So let's say negotiation starts on Friday morning, and the people had already gone on strike before Friday, and the case is still with you. I mean, you are trying to resolve it. You've asked them to go back to work on Friday. Do you expect them to go back on Friday, or you expect them to go back on Monday?
So far as the community has, out, you have to call it off and then adhere to the director of the commission. You have to call the strike off and continue with your normal work. And then, since the process is still ongoing at the commission, you have to call it off and go back to work.
Okay. So how many people sit on the table to determine or to discuss these issues?
We have stages. We have facilitation. I don't know whether you mean facilitation or the commissioner's hearing. Which one?
Both. You tell us about
Facilitation
it.
is done by the industrial relation officers. It's done within the staff of the commission, the industrial relation department.
Okay.
So let's say 2 or 3 people can sit on the case.
Okay.
And then the commissioner's hearing is done by 7-member board, 7 people.
And who are these people?
Two comes from the organized labor.
Okay.
2 comes from the employers association.
Okay.
2 come from government. And then the president or the
So
chairman
who
also
come
from government.
Who and who
side.
comes from the government side? Which part of government side are we talking about?
Government. Government in power.
And the government of the day.
Okay.
Yes.
And then 1 person from
2 from trade union,
organized labor.
2 from employers association,
Okay.
and then 2 from government.
Okay.
So making 6.
Yeah.
And then the president or the chairman is coming from the presidency. It's nominated by the president.
To sit on that.
Yes. To sit
Okay.
on the panel.
Okay.
So there are 7-member commissioners.
So after they have sat down, is there some sort of vote or something to determine which one would go for them and then which one would not go for them? I mean, in terms of whatever outcome that you come out with, something that you come out with.
They all decide together. They go into the matter, the issue.
Okay.
They decide. They take a decision together as a body.
And then okay. So
See, just to add to what my
Okay.
sister said, during the commissioner's hearing on such matters, taking into consideration the strike issues that we are talking about tonight, for instance, when the commissioners sit on it and the case is heard, there are stages of the hearing process. That is, they break into caucuses.
Okay.
And so, say the employer, after the plenary session, they can ask for a break in caucus. So the commissioners can meet with the employer after which the employer will take leave, and then the employees will also come, and we also meet with the commissioners. And so we listen to both sides on separate grounds, and then we bring all of them together, and then we hear from them again, after which the commission will now come up with a ruling or a directive as to what should be done. There are certain instances that after hearing both parties at the same time, they are made to even leave the conference hall, so that the commissioners, or they also have a chamber, they can go back into their chamber as commissioners, go and sit down for just a few minutes and make determination and come back, just as is done in the court. You know that the Labor Commission is a quasi-judicial body, and so they can go and make the determination and come back to sit with both parties, and then they give their ruling on the matter.
So in this instance, there's both parties, none of them are supposed to go on any demonstration while on strike. Is that also okay?
That's why I said during period of period, you don't have to go on strike. During negotiation, if negotiation is underway, it's in progress, you don't have to go on strike. When you do that, it's unfair. So the employer can decide not to pay you because negotiation is underway, so you don't have to go on strike. Yes.
You see, you can't even be on strike and negotiate. The law doesn't permit it. I see certain times we want to gloss over the law and do certain things which contravenes the law, and it doesn't help. You see, it's these unions and parties and associations that saw the need for the nation to have an act that will regulate employer-employee relationship. You see, and these laws came into force in the year 2003. And these are the provisions that the laws make. And so when it says don't do this, don't do that, it is expected that parties give reverence or respect to the laws that they themselves have helped in formulating. By so doing, then we are making progress as a democratic institution or country. See, but when we want to breach it, for instance, the law is saying that don't go on strike and negotiate. If you want to negotiate for any condition, call off your strike and go on the negotiation table. But others want to overturn the law in their favor, and it doesn't help anybody.
Interesting. Thank you so much. Well, I think on this note, we'll go for a break. When we come back, we'll continue shortly. Do stay.
Welcome aboard the safest airline in Africa. With industry-leading safety measures to protect your well-being. The first in Africa to earn a diamond standard of safety. Offering a more contactless, safe, and seamless experience. Delivered with a smile by Africa's first fully vaccinated crew. Creating special memories that bring the joy back to flying, so you can continue making memories with your loved ones. Book your flight with Ryanair today. Rwandair, the safest airline in Africa.
Rwandair, fly the dream of Africa.
Blue City is a manufacturer and supplier of high-quality fashion accessories. We design and make quality bow ties, flying ties, lapel pins, ladies' brooches, fabric necklaces, African wares, and so much more for your weddings, schools, institutions, bands, choir, singing groups, individuals, and so many more. We use both African prints and foreign fabrics to make your beautiful accessories for you. Oh yeah! Contact us via call or WhatsApp or SMS on 0240 926 564. Locate us at Odoko Official Town opposite Emils Preparatory School. Check us out on social media, Facebook and Instagram at Blue City Fashion. Blue City, creativity and
Welcome aboard the safest airline in Africa. With industry-leading safety measures to protect your well-being. The first in Africa to earn a diamond standard of safety. Offering a more contactless, safe, and seamless experience. Delivered with a smile by Africa's first fully vaccinated crew. Creating special memories that bring the joy back to flying so you can continue making memories with your loved ones. Book your flight with Rwandair today. Rwandair, the safest airline in Africa.
Rwandair, fly the dream of Africa.
All right, welcome back. Thanks so much for joining us. Don't forget, we're also live on Facebook. Don't forget to share your comments and your contributions with us. So, Eunice, why would the commission go to court?
The Labour
You want to
Commission,
enforce it, eh?
the Labour Commission will drag parties to court
Okay.
if maybe, for instance, the commission has given a directive and then the parties are not trying to adhere to. That is where the commission will go to court for the enforcement. Yes.
Fatima,
Yeah.
you support that argument?
Oh, yes.
Okay.
You see, like was mentioned, the law mandates the commission to sit on cases and to help in finding solutions to it. And so if after the hearing process, the commission gives a directive and the party fails to comply with it, definitely we will have to go to court. You know, we do not have the powers to enforce our own decisions. Certain times it needs a higher body to do that. So we go to court and then the decisions are enforced. See? So that is how come we go to court at or on such instances, just to seek for enforcement.
But do we pay them when they are on strike? Must we pay them? Eunice?
It depends on the issue.
Okay, so whatever the issue is, what issue would warrant the government or whoever is in position not to pay workers?
When workers are on strikes and they bring the matter to the commission, and the commission has given a directive that so and so date you have to call the strike off, and they are still on strike, the employer can decide not to pay them, and it is the right. I mean, it will be in the right direction for the employer not to pay them because they say you should call the strike off by the commission, and you are still on strike. The employer can decide not to pay you. Yes.
So, the way you are shaking your head, you are supporting this thing. Seriously supported it.
You see, ideally, strikes, like we mentioned, can be categorized into two. We have legal strikes and we have illegal strikes. And so when the case is heard at the commission and the commission gives a determination that due to this and that there were procedural breaches in the way you contracted or you went about the process of embarking on the industrial action, and so you should call it off and go to work, or you should call it off and go to negotiation table, and you refuse to comply by this directive, there is nothing that stops the employer from also stopping your salary for a period until you decide to go back to class or to work, and then you are paid. Under this democratic dispensation 1992 constitutional regime, we have had a government which was in power and a union embarked on strike, and it was determined that it was illegal. They said no, they will still sit in the house. Government froze their salaries. They were not paid for a period of about 2 to 3 months. You see? And so all these steps are processes that can be followed when one refuses to adhere to the provisions of the law.
So do you think this could reoccur again
It can. It is possible.
in this era?
Oh yes, it can occur. It can occur. Because for instance, you say you are on strike. Your case has been determined and it has been declared as illegal by the state institutions that we have established jointly to look into such matters when it arises. And you choose to determine or to decide on how you want things to be done. The government can take any decision. See, and they cannot be faulted for anything. They cannot be faulted because the procedure has not been followed.
So Eunice, if you are part of any association, should you inform the association before you decide to go on strike? And the other one, could your employer decide to terminate your contract based on a strike? And will it be termed as illegal termination of contract?
Okay, from your first question.
Okay.
When you belong to a union and you have any issue, the first step is to inform the union chairman or any union body within the organization about the issue. So they will file the complaint at the commission on behalf of you, the worker.
Okay.
So they will come to the commission that so and so worker has been terminated. So they will be like a mouthpiece for you. They will speak for you on the matter. Yes. But if you don't belong to any union, then you can come yourself to the commission to pick up a form and fill a complaint.
Okay. And I'm also talking about the termination of contract. After you have gone on the strike, I mean, you've said time to down number, don't go on strike. We are still on the issue, and then
So
they decide
the
to
employer
go.
has the right to terminate.
And is it legal?
Of course. Because maybe, for instance, you came to the commission says, do this, do this, do this, and you refuse to do that. The employer has the right to lay you off for any damages that you caused to the company.
Because in this laying off, if you are to be laid off based on this assessment, would you get any remuneration? Would you get a salary advancement? Would you?
Well, it depends.
Okay.
See, the first thing that will be looked at is the process that the parties took before they embarked on the strike. There has been a determination. You are asked to proceed to work, and you say no, you are going. Now, the employer has come in to terminate your employment. The employer can choose to give you anything that he feels he can give to lay you off. More or less, it becomes like a compensation, paying you for your severance, the period of time that you have engaged in a working relationship You know, as you work, the employer pays your SNIT and other things. Certain times your provident contributions and all of that, which are all your statutory benefits that you stand to gain. Your employer can then also come in to add your severance package, just to sever the relationship that is existing between you and the employer, and it ends there.
Okay.
Yes, but it is in very scarce circumstances, very rare circumstances, let me put it that way, very rare circumstances, that due to a strike action, an employer will terminate or will lay off the workers. There are many other grievance procedures that can be taken, or dispute resolution procedures that can be taken to ensure, if it is, for instance, say the National Labour Commission, that you feel that maybe you don't want the commission to now sit on your case again, you can call for an independent mediator to sit on such cases. You know, we have 3 stages of hearing some of these cases. We have the facilitation, the mediation, and the arbitration, which is a compulsory arbitration. And so if it is the Labour Commission that you feel maybe you are no longer interested in handling such matters, you can call for an independent mediator to sit on the matter. In Ghana here, we have quite a number of them. Mr. Austin Game of Game and Game Consult and other such reputable people. They can all be brought in to sit on the matter.
So you only bring a private person when you feel that the issue is not going in your favor?
It depends.
Okay.
Like I mentioned, maybe you feel that you do not want the Labour Commission to sit on the matter again or to hear the case again, but you feel that where it has gotten to, there must be a different face coming into the matter. Maybe you've seen the very same face at the table all the time, so you prefer that a new face also comes in. That one, you can opt for it, and the law permits it.
You mentioned 3 stages. Arbitration,
yes, facilitation and mediation.
Okay, so where have we gotten to in this current dispensation?
Which of them are you referring to?
I mean, why would we get to the third phase instead of maintaining the first, the facilitation stage or the mediation stage? Why would we get to the third
When
phase?
you bring a case to the commission, the first stage is the facilitation stage. So when facilitation failed, we deadlock it. We call it deadlock. So when there's a deadlock, it means the case has not been able to resolve. It will go to the next stage. That is the arbitration. Arbitration is not compulsory. It's a choice because it goes with a fee. You have to pay money for the hearing.
And who are going to pay the money to?
The parties will pay the money to the arbitrator.
And is the arbitrator coming from the Labour Commission?
We have a number of arbitrators.
Okay.
It's like they've registered with the commission, so they come to sit on the arbitration or mediation case.
So
they are not part of the commission, but like they are, let me say, HR experts or those who have experience in those industrial relations.
Yes, they have expertise in such relevant fields.
Okay.
So they come in, they are brought in to handle.
Yes, so the money goes. I mean, the fee goes to their. I mean, as for the service rendered to the commission, the money goes to them. The fee for the arbitration or the mediation.
Okay, so would there be a time when we'll decide not to go on strike in this country? Is it that the only issue or the only thing that whoever is in charge hears is the strike action and then demand to be met?
I'm not sure the number of cases or the strikes will end in Ghana, but the Labour Commission is established to ensure that industrial harmony is preserved in the country.
Okay.
Yes.
So we'll still go ahead with it.
It will continue, but we are trying to minimize it.
Okay.
Seriously, we are trying to. The Labour Commission is trying to minimize it. That is why when we hear that there's any strike case, we quickly try and then invite the parties to the commission to resolve the issue amicably.
So, for instance, the Labour Commission is currently carrying out a lot of activities just to sensitize the public on their rights and responsibilities at the working environment.
Okay.
And then the
Can you
employer
share a little with us?
also. Well, so when you are employed to work, there are conditions. Like my sister mentioned earlier, you are giving your contract of employment letter. You have your workers manual or your workers handbook, which spells out your duties and your rules and everything. You see, many reputable organizations are having these documents to help the workers, to guide them as to what should be done. Clearly, it also spells out the responsibilities of the employer. So, for instance, you have employed somebody to work for you. You are, say, a construction firm. You know you are supposed to provide the individual with protective clothing. If you are not doing it, this issue can be brought up at the National Labour Commission for a redress or to call the party to order so that such provisions can be made. You have been given a workers manual which stipulates your number of weeks or months you are supposed to enjoy leave in every year of your work, and then you are being denied. In this case, when it comes to the commission, we don't only consider what it is in your contract of engagement.
Okay.
We look beyond that. We can refer to the Labor Act, which is the supremo, which is the highest regulatory framework, which regulates all other institutions under the democratic dispensation of this nation. See, and so what it provides for, you can be referred to so that you adhere to it, or you give to the employer so that he can also benefit from it.
So if you are employed today and you realize that these list of things you just mentioned is not spelled out in any of the handbook or your employment letter, what happens? Should you ask for it?
You see, when you are employed, the employer will have to give you your job description.
Okay.
And so if that is not being followed, you can demand for it, and you have to be provided. For instance, you have been employed to drive in an organization, and certain times those who, unquote, would want to cheat you, they will state under your employment letter that and any other duties that your employer will engage you in. What are those duties that you can't spell out? If you feel that there are other duties that you want the fellow to do, it should be within what he is employed to do. So, for instance, you have employed me to come and drive in your organization for you. I come and tomorrow you want me to go to your house and be sweeping there. That is not part of my job description.
Okay.
I'm a driver. And so I have the right to voice it out. And so all these things come into play when the individual is contracted to work.
Interesting. Thank you so much. Any final words for us before we go?
Okay. My final words is that the Labour Commission is an independent adjudicating body. We don't belong to either the employer side or the worker side. We are for both parties. So if any issue, they should not hesitate. They should come to the commission. They should also think that because when you bring your case to the Labour Commission will be on one side. I mean, one side of the worker. We are there for both parties. So if you have any issue, you have to bring it to the commission than going on strikes or agitation and so on. Yes. So they should always come to the Labour Commission for further explanations.
Okay. Thank you so much. Fatima, thank you so much for your
You're welcome.
and for the education. I mean, the strike is not going to end, and we should also try as much as possible to minimize the strike. When the Labour Commission says it's going to work on something, please let's adhere to it. Let's wait for them. until they give us further notice or further directions on what to do. This brings us to the end of our section today on regulators. Thank you so much for watching. Those on Facebook, thank you so much. Those watching at home, thank you so much. My producers and my technical crew, thank you so much. You heard from the head of public affairs, NLC, that's the Labour Commission, Eunice Lawe, and you heard from EDK Totime. He's also a public affairs officer for the National Labour Commission. My name is Naa Afarley Quarcoo. Thanks so much for watching. We'll come your way same time next week, Monday. Before then, enjoy the rest of our program. Sports is up next.